10 landmark judgments of the Supreme Court, judgments which preserved the sanctity of our Constitution, enlarged the scope of our fundamental rights, judgments which will be commented upon till there is life on this planet. At serial number 10, Aruna Shanbag, v. Union of India, 2011. Aruna Shanbag was a young nurse at King Edward Memorial Hospital in Mumbai. She was brutally assaulted by a janitor, and for many decades she remained in a permanent vegetative state. Matter went to the court, and the Supreme Court, a two-judge bench of the Supreme Court in 2011, legalized passive euthanasia in India. That's why it is a landmark judgment. Not just this. Few years later, in 2018, in a case known as Common Cause v. Union of India, Supreme Court ruled right to die with dignity is also a fundamental right under Article 21 of the Constitution. Supreme Court provided for advanced medical directive. Living will is also a fundamental right under Article 21, and thanks to Aruna Shanbag verdict of 2011. At serial number 9, Navtej Johar v. Union of India, 2018. It was this judgment where the Supreme Court invoked constitutional morality and decriminalized homosexuality. So Section 377 of Indian Penal Code, which criminalized homosexuality. Homosexuality was a crime. It was decriminalized in this landmark judgment of the Supreme Court delivered by a constitution bench, a five-judge bench of the Supreme Court in 2018. At serial number 8, Vishakha, v. State of Rajasthan, 1997. Bhamri Devi was employed by the Rajasthan government to ensure that she plays an important role in convincing the people that you should not resort to child marriages. Child marriages are a menace. She tried to convince people not to resort to child marriages. And what she received in return, she was gang raped by 5 men. Ironically, the High Court acquitted all these men. Ironically, the High Court said maybe rape did not take place because one accused is the uncle and the other is a nephew. It is inconceivable that in Indian culture we will see that an uncle is raping somebody in presence of the nephew, or the nephew is raping somebody in presence of the uncle. Maybe rape did not take place. In fact, the Supreme Court said, even the High Court said, what was the husband of Bhamri Devi doing? Why did he not help her? Long story short, Vishakha, a non-governmental organization, approached the Supreme Court, and Supreme Court issued guidelines in 1997 under Article 141 of the Constitution. And these guidelines provided for guidelines, rules to protect sexual harassment of women at workplaces. And it is this judgment of the court in 1997 which resulted in the POSH Act being enacted by the Parliament in 2013. Remember the name, Vishakha v. State of Rajasthan, 1997. Judgment at serial number 1, Minerva Mills v. Union of India. Constitution was amended in 1971. Constitution said, if the Parliament wants to give effect to two directive principles of the state policy under Article 39B and 39C, even if this law violates 3 fundamental rights under Articles 14, 19, and 31, the law would still be valid, which means 2 directive principles of the state policy were given primacy over 3 fundamental rights. The year was 1976. 42nd Constitutional Amendment Act was passed. This nation was in a state of emergency. And now the Parliament said, under Article 31, capital C, that if the state wants to implement one or more directive principles of the state policy, and in the process, the law violates 14, 19, and 31, 3 fundamental rights, the law will prevail. Long story short, it meant that Parliament, by amending the Constitution, is giving primacy to all directive principles over 3 fundamental rights. Supreme Court said no. There is a relationship, a harmonious relationship, a balance between directive principles and fundamental rights. And this balance you are trying to disturb through this 42nd Amendment, and thereby you are violating basic structure. Supreme Court reaffirmed the doctrine of basic structure in this case, and Supreme Court said judicial review is part of the basic structure of Indian Constitution. So judicial review as a part of the basic structure, balance between directive principles and fundamental rights as part of the basic structure. This was ruled by the Supreme Court in this landmark judgment of Minerva Mills v. Union of India, 1980. At serial number 6, Supreme Court had to decide. A 9-judge bench of the Supreme Court had to decide whether reservation of 27% up to 27% for OBCs, whether it is constitutionally allowed or not. Supreme Court upheld OBC reservation. But Supreme Court said, in order to provide for 27% reservation, Indra Sawhney v. Union of India, also known as the Mandal case, Supreme Court said you have to meet 5 constitutional requirements. Those castes who are providing reservation, they should be socially and educationally backward. And these castes should not be adequately represented in the administration. Concept of creamy layer for OBCs was introduced because of this judgment. Supreme Court said reservation is possible as long as you are maintaining efficiency in administration. And finally, the Supreme Court said reservation cannot exceed 50%. So reservation for SCs, STs, OBCs combined should not exceed 50% unless and until there are exceptional circumstances. Supreme Court said reservation can only be at the time of the recruitment, not at the time of the promotion. Supreme Court said reservation for poor is constitutionally invalid because Constitution only provides for reservation for socially and educationally backward. Although now we have 10% reservation for economically weaker sections of the society. Now we have reservation and promotion also, but for SCs and STs. But this 50% cap on reservation, which even today is hotly debated across the political circles, that is thanks to Indra Sawhney v. Union of India, the Mandal case. Although previously also in one judgment, Supreme Court had introduced this limit of 50%. But Indra Sawhney becomes important because 27% reservation for OBCs was upheld because of this verdict. At serial number 5, S.R. Bommai v. Union of India, it is argued that it is this judgment which has prevented the misuse, the overuse, the abuse, the hyperuse of Article 356 of the Constitution, which deals with President's rule. In this case, Supreme Court said federalism is part of the basic structure. Secularism is part of the basic structure. If you think, dear governor, that a particular chief minister does not enjoy majority, that majority needs to be tested on the floor of the Legislative Assembly. So floor test is a must to ensure that you prove that you have majority on the floor of the Legislative Assembly. Because Karnataka chief minister was dismissed. Few state governments were dismissed in the aftermath of the Babri Masjid demolition when there were riots in different states. Supreme Court said secularism is part of the basic structure. Federalism is part of the basic structure. And it is this judgment, landmark judgment, which has prevented the misuse of Article 356. The Supreme Court made a distinction between breakdown of law and order and breakdown of constitutional machinery. If there is a breakdown of constitutional machinery, that's a fit case for President's rule. Mere breakdown of law and order cannot be invoked to impose Article 356. We are talking about 10 landmark judgments of the Supreme Court. And on the 10th of December, Unacademy would be celebrating its 10 years of existence. And for that, we are commemorating it and we are celebrating it. A big event, a massive event is planned on the 10th of December on Unacademy Unstoppables YouTube channel. The link is provided in the comment section as well as in the video description. Click on that link, press the notify me button, and we will see you on 10th of December. Something big is happening. A legend is coming. Some big reveals are going to take place. For that, press the notify me button. Landmark judgment at serial number 4, Puttaswamy v. Union of India 2017. A 9-judge bench of the Supreme Court ruled that right to privacy is a fundamental right under Article 21 of the Constitution. Aadhaar as a law was enacted by the Parliament. This Aadhaar was challenged in the Supreme Court by a former Karnataka High Court judge. But for that, the government of the day said right to privacy is not a fundamental right, because the petitioner is arguing that because of Aadhaar, right to privacy is getting violated. Right to privacy is not explicitly mentioned in the Constitution. The government said, look at MP Sharma case of 1954. Look at the Singh case of 1962. In both these cases, the Supreme Court has upheld that right to privacy is not a fundamental right. And what Supreme Court did in Puttaswamy case, a 9-judge bench of the Supreme Court, by the majority of 9-0, said right to privacy is a fundamental right under Article 21, basically negating the MP Sharma case and the Singh case. That's why it is a landmark verdict. At serial number 3, Shreya Singhal v. Union of India 2015. Parliament amended Information Technology Act and added Section 66 capital A to the Information Technology Act in the year 2008. This section said whoever is using a computer device, an electronic device, whether a smartphone, laptop, desktop, palm top, if you're transmitting messages which cause annoyance to somebody, you are a criminal. This is where 2 students were arrested when they wrote something on their Facebook pages. Shaheen Darda was a lady from Maharashtra who commented on her Facebook page, why is there a need to enforce a bandh when Shiv Sena Supremo Balasaheb Thackeray has passed away? Her friend liked the status. Both were arrested and booked under Section 66A. Why? Because it caused annoyance to members of the Shiv Sena. Shreya Singhal, a law student, approached the court and said, my lord, Section 66A criminalizes free speech, violates the fundamental right under Article 19(1)(a) of the Constitution, freedom of speech and expression. Supreme Court said this Section 66A is unconstitutional because it violates Article 19(1)(a). Why is this an important judgment? Because Supreme Court said say whatever you want to say, express whatever you want to express, advocate whatever you want to advocate. You should not be inciting people to violence. If your speech leads to violence, then it can be criminalized. Otherwise, say whatever you want to say, express whatever you want to express, advocate whatever you want to advocate. That's thanks to Shreya Singhal v. Union of India 2015. Now, the last 2 landmark judgments, I think everybody would be guessing right. At serial number 2, Maneka Gandhi v. Union of India 1978. Maneka Gandhi's passport was impounded without giving her the reason, without giving her the opportunity to challenge the impounding of her passport. Matter went to the court. And the court said, we don't follow just procedure established by law. We follow the American equivalent of due process of law. Not just that, we follow principles of the natural justice. Because prior to this judgment, if a law was passed, because during emergency, MISA, Maintenance of Internal Security Act, this law was heavily misused by the government. Activists, trade union leaders, journalists, opposition leaders were arrested, and habeas corpus was suspended. You can't even approach the court if you have been booked under MISA. Matter went to the court, ADM Jabalpur, 1976. The infamous habeas corpus case. 4 judges of the Supreme Court said habeas corpus is suspended during emergency because we have to follow what the law is dictating. If the law says you can't approach us, you can't approach us. But this ADM Jabalpur case, which was considered to be the black spot on Indian judiciary, in 1978, Supreme Court took a completely different view. Supreme Court said any law which is passed by the parliament, it should not only satisfy Article 21 that just the procedure has been followed and the law is valid. The law has to satisfy Article 14 as well, which talks about right against arbitrariness. Because if your passport has been impounded, you should be told the reasons. You should be given an opportunity to challenge it. If you're not giving the reasons, you're not giving the opportunity to challenge your impounding of the passport, which means your law is arbitrary and it violates Article 40. And if you're denying Meneka Gandhi from traveling abroad, you are violating her Article 21 as well, but you are violating the freedoms available under Article 19, freedom of speech and expression. This is where the court invoked something called golden triangle. Supreme Court said a law has to be just. The procedures mentioned in the law have to be fair, reasonable as well. A law will have to justify not just Article 21, but Article 14, Article 19 as well. And landmark judgment at number one. Till the time Indian Constitution is discussed, Keshavananda Bharati would be discussed. 13 judges of the Supreme Court sat for 68 hearings. This judgment was in more than 700 pages. When the Attorney General was asked to present his view, he compared the constitution of more than 60 countries of the world. But the fundamental question before the court was, is the power of Parliament supreme that it can amend any provision of the Constitution? By a wafer thin majority, 7-6, Supreme Court said no. Parliament does not have the power or a sovereign power or an unlimited power to amend any provision of the Constitution. Yes, you have the power to amend the Constitution, but that would be subject to basic structure. Nani Palkhiwala was the lawyer who defended Keshavananda Bharati in this case. Nani Palkhiwala asked simple question to the court. Nani Palkhiwala asked, "My lord, there is an implied restriction. Although if you look at the plain reading of the text of the Constitution, there is no limitation on the amendatory powers of the Parliament. Nowhere is it mentioned in the Constitution that Parliament cannot amend so and so features. Although there was some restriction under Article 13, where the clause 2 of Article 13 said the state cannot make any law to delete, abridge fundamental rights. Apart from that, there was no restriction. Article 368 could be used to even amend fundamental rights. Nani Palkhiwala said there is an implied restriction. If there was no restriction, he is asking the court, 13 judges of the court, that what stops a future government from using Article 368 and converting the sovereign state of India and give it back to the British? Can the Parliament use Article 368 to gift our country back to the British Empire? Can Parliament use Article 368 and say from now onwards there won't be any elections in India? Can Article 368 be used to say there is no right to life? Or forget about it. Can Article 368 be used to amend every provision of the Constitution to such an extent that at the end, nothing is left in the Constitution? You are abrogating Article 368. It's abrogating Article 368 to Article 368, Constitution itself. Carefully. Is there an implied restriction? Is Parliament limited from doing something? Because if there is no limitation, then what stops the Parliament from using Article 368 to remove one by one every provision of the Constitution to reach a point where you are abrogating the entire Constitution? Should Constitution stay? At least some bits should stay. That is implied restriction. Although the court did not agree with this argument of Nani Palkiwala as implied restriction, the court invoked something called basic structure, saying basic structure cannot be violated. And later on, Supreme Court keeps on expanding what constitutes basic structure. Parliamentary democracy is part of the basic structure. Rule of law, free and fair elections, independence of judiciary, secularism, federalism, the objectives which are enshrined in the preamble, they are part of the basic structure. The landmark judgment at number one will always remain a Keshavananda Bharati v. State of Kerala 1970. If you like this video, got benefited from this, please do not forget to press the like button, subscribe to our channel if you have. Thank you for watching.